Everything explained in this video is summarized from the CoinMarketCap. And also, please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now, take a look at this. SEC drops charges against Ripple CEO Garlinghouse. The agency had previously identified them as defendants in its securities violation case that was centered around XRP transactions. However, the vice president of Ripple, Brad Garlinghouse, and Gary Gensler of the SEC. The images were taken by Kevin Dietsch Getty and Scott Moore Shutterstock CoinDesk. The vice president of Ripple, Brad Garlinghouse, and Gary Gensler of the SEC. The images were taken by Kevin Dietsch Getty and Scott Moore Shutterstock CoinDesk. Ripple's top leaders have been exonerated of the securities violation allegations brought by the Securities and Exchange Commission, which have been dragged out for years through the various federal courts. This brings the overall case closer to an initial resolution and possibly even closer to an appeal. One of the bellwethers in the continuing disagreement between the cryptocurrency industry and the SEC regarding the definition of security is the case that is now being discussed. The Securities and Exchange Commission of the United States will no longer pursue allegations that Ripple CEO Brad Garlinghouse or Executive Chairman Chris Larsen aided and abetted the company in violating federal securities laws in its XRP transactions. This decision will result in the cancellation of a trial that was scheduled to take place in the following year. Additionally, this decision will provide the cryptocurrency company with yet another victory in the agency's ongoing lawsuit against it, while also bringing the regulator closer to appealing a decision made by a federal judge in the case. According to a document that was submitted on Thursday afternoon, the parties reached an agreement to voluntarily drop the charges of aiding and abetting that were brought against the two executives with prejudice. This means that the allegations cannot be brought again. The filing stated that the Securities and Exchange Commission would proceed with its charges against Ripple. For nearly 3 years, Chris and I have been the subject of baseless allegations from a rogue regulator with a political agenda, said Garlinghouse in a statement. These allegations have been false and have been made against us. Instead of looking for the criminals stealing customer funds on offshore exchanges that were courting political favor, the SEC went after the good guys. The advertisement in July, the judge who was hearing the case found that Ripple had not broken federal securities laws by making XRP available to individual investors by placing it on exchanges. This was a significant victory for Ripple, even though it was only partial. The same verdict was issued by Judge Annalisa Torres, who stated that the business had violated federal securities law by selling XRP directly to institutional investors. As indicated by the filing that was submitted on Thursday, the SEC and Ripple will continue their conversations throughout this second segment. In a similar vein, the charges that were dismissed are connected to the institutional sales, which were scheduled to be tried in April of the following year. The CSC and Ripple intend to meet and confer on a potential briefing schedule concerning the pending issue in the case. What remedies are proper against Ripple for its Section 5 violations concerning its institutional sales of XRP, according to the regulatory filing? The SEC representative declined to comment on the matter. The transaction was referred to as a surrender in a press release issued by Ripple, while the initial chase was referred to as absurd theatrics. However, their attempt was unsuccessful. The advertisement, while the Securities and Exchange Commission has been pursuing cryptocurrency companies that it believes violate securities rules, it has encountered several legal obstacles. Although Gary Gensler, the chair of the Securities and Exchange Commission, has claimed that practically all cryptocurrencies need to be regarded as securities within the purview of agency control, judges in the United States have consistently stated that this is not the case. These court battles may wind up establishing the rules by which the United States government deals with digital assets. This is because Congress is not likely to pass any crypto regulating regulations shortly. Meanwhile, Ripple has stated that it is now conducting roughly 90% of its operations outside of the borders of the United States. Catherine Kirkpatrick, the chief legal officer at CBO Digital, stated in a post on X, which was formerly known as Twitter, that the organization may have withdrawn the proceedings against the individuals as a legal strategy. This means they can proceed to appeal the Ripple decision much sooner. Otherwise, they would have had to wait until the conclusion of that trial in the late spring. She stated in her letter, the court has handed down its summary decision and dropped the remaining accusations in the case between the Securities and Exchange Commission and Ripple Labs. Despite these developments, the years-long legal battle is far from ending. Ripple and the CC continued to battle this week over one of the final elements of the case, what records the cryptocurrency issuer has to produce so the court can dole down injunctions and civil penalties. The SEC has asked the judge to require Ripple to produce its financial statements from 2022 and 23 and contracts about institutional sales that are dated after the securities agency filed its original complaint in December 2020. Since the complaint was filed based on contracts dated before the complaint, SEC attorneys have also requested that Ripple disclose the amount of money it made from institutional sales. The SEC could have requested this material during the open discovery process, according to Ripple, who called the request untimely. Furthermore, the SEC's demands are baseless and irrelevant, according to a court filing from Ripple's defense team on January 19. This is because the information the CC seeks has no bearing on the court's remedies determination. In response, the SEC filed a court filing on January 23. It claimed that the discovery time was still open, citing the court's November ruling that remedies-related discovery would be permitted until February 12, 2024. Additionally, the agency contended that these records are necessary to ascertain if Ripple committed new violations after the SEC's initial complaint was filed. Through summary judgment, the court awarded Ripple a partial victory after presiding judge Alyssa Torres determined that the company's programmatic token issuance of XRP was not classified as a security. According to CEO Brad Garlinghouse, the business has invested more than $150 million in defense. In part, Torres' decision supported the SEC concurring that Ripple's institutional XRP sales constituted the offering of unregistered securities. For the other matters, the judge ordered a trial. These included claims that co-founder of Ripple, Chris Larsen, and CEO Brad Garlinghouse had assisted and encouraged violations of securities laws, but in October, the SEC abandoned these accusations. The SEC is required to file its remedies brief by March 13, 2024, if the parties can reach a consensus on remedies-related discovery and the court can adhere to Torres' original schedule. After that, Ripple has 1 month to submit any opposition. According to a court filing in New York, on Thursday, the U.S. Securities and Exchange Commission has withdrawn its accusations against two executives of Ripple Labs in its lawsuit, claiming that the blockchain startup breached U.S. securities legislation. The government has stated in legal documents that it is withdrawing allegations that Ripple chief executive Brad Garlinghouse and co-founder Chris Larsen assisted and encouraged the selling of the cryptocurrency XRP, which a judge has determined to be unregistered sales of securities. The SEC filed a complaint in December 2020, alleging that Ripple unlawfully generated over $1.03 billion through the sale of XRP, which was not registered as a security. In July, U.S., District Judge Alyssa Torres in Manhattan ruled in favor of Ripple to some extent, determining that the selling of XRP on public exchanges did not qualify as unregistered securities offerings,